Sorry, I think my mic was unmuted, so start again. Uh, we welcome you to lawyers across the globe and around the clock for the Rule of Law, an unprecedented Rule of Law 24-hour webathon. This is Umar Al-Hulu, a partner in Hadaf and Partners and a member of the International Association of Young Lawyers, AIJA. This panel, presented by AIJA in collaboration with UAE Association of Lawyers and Legal Consultants. We will discuss today a case for global climate justice. What is the dream goal and what are the odds of achieving it? We are one of 12 different panels being offered for 24 continuous hours by bar associations worldwide to celebrate, address challenges, and defend the rule of law, all on this YouTube channel. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we, lawyers, are often the first line of defense. The rule of law is not merely the stock and trade of lawyers. No, it is our core value. The universal commitment of the world's lawyer to the rule of law inspired us and many other law societies to join forces and launch this first of its kind webathon. We are proud to be part of it. I'm delighted to have two distinguished Emirati speakers in this panel, Dr. Mohammed Al-Shamsi and Dr. Saeed bin Safwan, and we will start with Dr. Saeed. Dr. Saeed is a lawyer and the founder of SBS Law Firm. He is also an assistant professor in UAE University and the head of the legal clinic in the UAE University. Dr. Saeed will shed the light on an interesting topic, the climate change litigation. Dr. Saeed, the floor is yours.
Thank you, Mr. Mohammed. Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning to all of you. Yes, first of all, I would like to thank AIJA, thank Mr. Mohammed for this invitation. Surely the climate change topic in general is a very important topic, and its importance coming more and more every day and every year, since Paris Agreement, since the agreement and the world, the whole world is thinking about this topic these days. But always we see this this topic as a climate change topic is always was been outside the courts. It's always outside the courts. We see plans, we see it in the media, we see it everywhere, but not in the courts. That's why I choose to talk about this topic. And before talking about it in details, I'm not sure if I can share my PowerPoint here, or you can help me in sharing my PowerPoint. Before talking about this topic, Mr. Mohammed already introduced me to all of you. My name is Dr. Saeed Al-Ali, and I'm assistant professor at United Arab Emirates, director of legal clinic and founder of SBS Law Firm. And at the same time, I'm a lawyer and a legal consultant. The reason of choosing this topic, as I already said, it's because this issue, the climate change issue, has been always outside the courtrooms, and there is a famous saying by Judge Antonio Herman Benjamin, He said, if judges are in charge of deciding all sorts of conflicts about life, death, love, human rights, and national security, it makes no sense that to leave climate change outside the courtroom. So yes, it's important to think about it in this way. So yes, climate change has taken the full attention in media, in policy, in politics, in every aspect of life, but not in courtrooms. So that's why we as lawyers, we need to take it to the court in order to give it more protection. But there is problems could face us as lawyers when we decide to go to the courts. First of all, we need to know what does the climate change litigation means. It means basically any case that brought before judicial court or even administrative or specialized tribunal that have one of the following specifics. First of all, it could be the reason of this case to raise a climate change as a central issue. So we are going to the court only for this issue, for the climate change issue. Or we could go to the court as a side issue. So we are going to the court for to protect a right, for example, one of the human rights, like a right of life or a right of dignity or any other rights. But in the same time, we are also raising this case for a climate change, but as a side interest here, or any case that include any effect on the climate change, any effect. So it could be a little bit far, but the outcome of this case could affect positively the climate change issue. So like closing a factory or closing a polluter factory, or any outcome of any case that affect the climate change. So yes, it's not only we should not only focus on the climate change as a central issue. We can use another ways to protect the climate change, or to help in this issue, but the outcome will help in this issue. After
Dr.
we
Saeed,
know...
Dr. Saeed, sorry to interrupt, but first of all, the admin, could you please allow us to share the our screen in the video, please? Because Mr. Saeed would like to share his PowerPoint. If that's possible, please. يلا تمام. Dr. Saeed, you can share your screen or your PowerPoint.
Actually, I'm opening the Zoom meeting in phone.
Okay, I see. So it's fine. I will try to share it myself. I will try to share it now.
Okay, thank you very much, Mr. Mohammed, Mr. Omar. So, so these cases are, first of all, when I chose this topic, I thought they are not so much cases talk about this, but they are increasing. They are increasing. And most of these cases that cover climate change, mostly in Asia or the Pacific, and usually against the government. But there is also a large number of cases against private entities. The basis of these cases usually the international treaties, the rights, and inshallah we will cover them after a while. But we always, as a lawyers, face the problem of standing. So if we go directly to the court and ask for an action against climate change, surely we will face the issue of the standing. And the issue of standing is known by lawyers. And if the lawyer or the plaintiff don't have the standing, this will cause the case to be dismissed. So that's why we need first to address this issue, then we will cover the basis of each or the basis that we can use to raise the lawsuit. In general, the standing means that the plaintiffs must prove that they have sufficient stake in the outcome of the case and that the judiciary can offer adequate address. And plaintiff also must have a sufficient or special interest in the subject matter of the action. For example, in the US, the party should prove that he suffered an injury in fact or in immediate risk of injury. The injury is fairly traceable to the defendant allegedly unlawful conduct, or the injury can be redressed by favorable court decision. So there is a conditions for the standing in US or in every country. But if we choose to go to the court and the central issue is the climate change, we could face an issues here or a problem here to prove that we have standing, especially when we are talking about the injury in fact or injury in imminent risk or injury, and the injury is traceable to the defendant. So this could be hard to prove. And we'll see later on the presentation that yes, there is a way to go around the standing issue, and this is the goal of this presentation, to give you a ways to use as a lawyers to fight to fix or to try to fix the climate change issue in the courtrooms. There is also a case in US. It was between a group of states and environmental organization and a couple of environmental organizations. All of them challenged the EPA, the Environment Protection Agency. And the basis of this litigation was to not, because the EPA did not regulate the GHG emission, especially for the motor vehicle emissions. And they choose not to regulate it. The court assured that the state of Massachusetts have the standing here. Why? Because they have an actual harm as the climate change affecting a large part of Massachusetts land. So that's why the Supreme Court here assure that this state have the standing. So here they prove the actual harm, and this is a one way to do it. This is maybe the easy way to do it. But if we see the same problem in another countries, for example, in Europe, the standing issue is a little bit harder, because the standing in Europe requiring that the harm should be particular to this plaintiff, and not affecting other people. So if the harm or the injury affecting all the people, so there will be no standing for this plaintiff. So it is harder in Europe to prove that the plaintiff have standing. And there is a case here. In this case, the court or the judge refused to dismiss the case based on the standing, because the plaintiff did not prove that he have a particular harm. So the harm, he proved that there is a harm, but the harm was for all the people, not only for the plaintiff himself or the group of plaintiffs. They were 10 families and some environmental groups. So at the end, the court dismissed the case based on the standing. And believe me, in the real life, as a lawyers, standing is a very important issue to think about it, especially when there is no right in the Constitution or even in the regulations that protect the environment or protect the movement against climate change. So we need standing. We need to find a way to go around the standing problem before going to the court and getting the case dismissed. So what is the basis that we can use after we check the standing issue and we find a way around the standing issue? And this also this basis could help us in solving the standing issue. So the lawsuit basis could be right-based action, whether this right is constitutional right or human natural right, or even right found in statutory or policy. So yes, we can use, for example, right of life, or right of dignity, or right of health. Many constitutions in the world guarantee this right. So we can use these rights and claim that the factory or the government or any defendant that we choose is infringing this right. But the main issue that we are claiming here is to act actively in the climate change management, but we choose to use the right as a way to prove the standing and to prove that yes, our rights was harmed here or injured. Also, we can use use the agreements, the international agreements like Paris Agreement, and the government compliance to these agreements as a law basis, especially the countries that sign these agreements. And UAE one of these countries. Also, we can use if the country have regulation or statute covering the climate change issue or covering environmental aspects, we can use this statute as a basis to sue the private entities and to require them to compliance with these statutes and regulations. And also we can use tort-based claims, especially the negligence and non-AIJA. So we can use the torts also here as a basis of climate change lawsuits. Also, wrongful damage to forests. Some of the countries have statutes or regulations that protect the forest. We can use them as also as a basis, and we will show in a while, inshallah, case from Indonesia that talk about the forest and how the plaintiff choose to choose the forest or the regulations related to the forest as a basis of his lawsuit. In general, the rest of this presentation, inshallah, will be about cases, and we show examples of cases that some of them or most of them prevail and was a successful cases and have direct or indirect effect to the climate change. To take them as an example, if we want to move for positively in the climate change movement in the court rooms. So we will begin with Asia in general and India specifically, because India was have many cases regarding the climate change, and the courts in India, the Supreme Court in India, included the right to clean and function environment within the right of within the human rights. So knowing that the plaintiff, knowing that he have a right to clean and function environment, and if we found a factory that pollute the rivers, for example, or pollute he have the emissions more than the standards, so he can raise a claim or raise a lawsuit based on his right to clean and functional environment. So by using this right, we solve the standing issue. So some of the countries, yes, have the rights, these rights, and the plaintiff can use them. But some countries, we will see that they don't have a specific rights as India. So we should we will see how the lawyers deal with that case. The courts in India, when they include the right to clean and function environment, they saw the environment damage and climate change as a factors to deprive the citizens of their capacity to live fully and with dignity, and threatens to deprive people of food, water, health, security, education, and also their homes. because we heard many floods that happens in India, in many countries, especially the Asian countries. Therefore, the climate change issue is threatening lives, threatening human rights, threatening the constitutional rights. So that this could be a basis for a lawsuit. We can use these rights, the right to clean and functional environment, or any constitutional right. We can use it as a basis to fix or to try to fix the courtroom part of the climate change issue. Also, there is another case here, also in India. In this case, the court held that the right to life is including the right to pollution-free water and air. So we can also, this could be a basis for a lawsuit if someone chooses to raise a lawsuit against a factory that have above the standards emissions. So he can use this right as a standing here and try to have like action against this polluter. The same thing also, the right to life and dignity. Also, another court decide that this right include the right to live in hygiene environment. So this is the cases in India. This is the cases in India, but the India was not the only country that act on this topic. Also, here we have Nigeria also. Nigeria or covered this topic in many cases. Here we just use one example here. Also, the court choose or held that the fundamental right of life, health, and dignity is also including the right to healthy environment. So this also can be used in Nigeria. So we covered now India and Nigeria. So these two countries will not have any problem in standing, and these rights could be used as a standing, and later maybe claiming for a compensation or claiming for injunction order or any another order that will have eventually effect on the climate change issue. In Nepal, also there is a couple cases that cover this topic on the same way, the exact same way. The constitution give the people the right to social justice, and the court included the right to live in a clean environment in the social justice constitutional right. Also, the right of life was also interpreted as a clean, as the right of a clean environment is included under the right of life. So it will be the right to clean environment or live in a clean environment will be either under right of life or under the social justice constitutional right. So In either way, Nepal, you can use these rights as a basis of your case, and later on, when you go to the court, you will be able to have an action or order from the court. The basis of this order will be your right, correct, but the outcome will affect eventually the climate change. In Colombia, also, there is a constitutional right of life, health, minimum substances, freedom, and human dignity. The court also include the right to healthy environment under these rights, and also the same thing will happen here in Colombia. The people can fight and can use these rights to get a positive outcomes for the climate change issue. In Bangladesh, the same thing. We generally the most of the countries covered here are Asian countries, because they are affected by the climate change more than the Western countries, and usually they don't have the sources to fight this issue. Not if we compare with another Western countries, we will find a big gap between the sources between the two sides. So in Bangladesh, the same thing happened. The right of life is including a right to environmental protection and preservation the environment. Also, in Pakistan, the same thing. The right of life include a right to clean environment. And in each country, this is only an example case, but there is a lot of other cases that cover the same thing. So I think with these cases, we can say that in many countries, no, we don't have a standing issue if we choose one of these rights. So the lawyer should be clever, as always. Lawyers are always clever. Should choose the right basis of their claims. If they choose to go to the court based on the climate change, directly the case will be dismissed. So choose one of these rights, and usually that will lead to a successful case, inshallah. But here, as we said, the majority of these cases was in Asia. But now we have also a case in Netherlands, and this one is a famous case. The basis of this case, it was based on the ECHR, the human rights agreement between the European countries, and the court in this case did not use the constitution of Netherlands. No, it used the Article 2 and Article 8 of this agreement. And Article 2 and Article 8 of this agreement protect the right to private life and family life and home. So, the court used these rights as basis of the judgment. So here the government, the court ordered the government to modify the plan and to take the care and to take actions to solve their plan, or to fix their plan for the climate issue climate change issue based on these rights. So yes, this case was more clear than the other cases. This case was directly affected the climate change plan in the country. So the Netherlands choose to reduce the emissions by 17%. And the court said, no, this percent is not enough, based on Paris Agreement. And the court ordered the government to reduce the emissions by at least 25%. So the outcome of this case affected directly the climate change issue, and the basis of this case was not the climate change issue, was the right of life and right to private life, family life, and home and correspondence. So we see the difference here between the basis of the case and the outcome that we find from this case after getting the judgment. Here is also another basis of the climate change cases. The cases that we already talked about was about the rights, using the right of life, using a right of private family, or any other rights, because either constitutional right or right on the agreements. But in this case in Sri Lanka, the basis was nonsense. So in this case, the residents of this city that I mentioned here in the case sue the factory because the factory pollute the air and pollute the water, but they did not use the right of health, or right of life, or any other right. They use the public. The basis was the public nuisance under the Code of Criminal Procedures, and they use another way. But eventually, the outcome of this case was to stop this factory and close this factory and stop this factory from polluting the air and stopping the emissions and polluting the air, as we said. So this also this is another way to try to have a case and to further help in the climate change issue. Negligence. Also, we will mention the same case that we already mentioned in Netherlands. In this case, there was a two parts. Yes, they used the human rights, the European human rights in general, but they also used a statutory obligation on the government to take care of their citizens. So one part was the rights that in the human rights agreement, but also The other part was the Netherlands Civil Code recognized that government owes the duty to care to its citizens. So also the negligence here was a basis to raise a lawsuit against the government, or maybe it could be used for the private entities if the law require them or they require the private entities to do or to act positively on something, but there was negligence for doing this this duty. So negligence also could be used as a basis of the climate change issues. And for the forests, I think this is one of the most I like personally I like this case because the Supreme Court of Indonesia, after they found two mining companies responsible for clearing protected forest to build the road to their mining locations and other illegal activities. So the factories, yes, they did illegal activities, and this illegal activities and clearing the forest cause an environmental harm. The ministry here asked the court for compensation, and they specify the compensation for each ton of carbon. So they said the illegal activities and clearing the forests released 359 tons of carbon per hectare. So they specify a number here. Therefore, illegal activities and clearing the forest in 208 hectares of damaged land released up to 74,672 tons of carbon. So they have specific numbers of how much carbon was released, and they have the number of the hectares. So after all of that, they specify the cost of restoring the released carbon. So not restoring not restoring the forest. No, they described it as restoring the released carbon, and they specify a number here, 90,000 rupee, I think, per ton. So this case was like an excellent example or excellent case that shows us that yes, we can calculate the damage even on the environment, and we can sue the private entities based on climate change or based on even maybe this solution to start fining the private entities or fining the polluters of the air, or fining any factory that is not complying with this standards. Maybe this will be the solution for the, or at least it will help for the climate change issue, because most of the cases was just injection order. So just the order, the court to stop the factory from polluting the air. So this factory will be either will have order from the court to stop polluting the air. So the factory will still there, and they will find a way eventually. They will find a way to pollute the air or pollute the water or any type of pollution. and many ways of pollution is not clear to everybody and all government entities, and also checking the compliance of these factories are it's another issue. The government itself, or the ministry that supervise this issue, is also another issue here. So some countries have a perfect codes and perfect laws, regulations, but the problem in applying these regulations. So this is also another issue we need to cover in maybe next time. The last thing that could be a standing for climate change cases is greenwashing. Greenwashing is basically falsely claiming that the project or product is green or has reduced carbon footprint. So yes, we need to protect these products, and falsely claiming that this product is green, and if we did not punish who is greenwashing, this will cause to have a lot of products that are claimed to be green, but at the end they are not green. So this will affect the movement against the climate change. And here at the last slide, I just want to mention the role of UAE, or what UAE did in regarding the climate change issue. We don't have specific cases talk about the climate change. All the cases that I saw, they are talking about heavily rain or flood or something happen without it's usually the first major cases, and they sometimes link the first major cases with the climate change, but usually the courts in UAE until now did not recognize the climate change issue. It depends on the judge, it depends on the court. Every judge deal with it in another way. So some of them force majeure, some of them use the contractual rights, and it's not totally clear here in UAE how to deal with the climate change action in the courts. But yes, we have in the constitution and the right of life, the right of many rights that covered here in this presentation are also covered in UAE constitution. But there is no clear cases until now. Maybe this will be the beginning of taking steps to check if we can act in the courts if there is a companies, for example, or private entities do not complying, and the law gives us the right to go to the courts to ask for injections or injection orders to stop the polluters. But until now, I didn't see any case in this regard. In UAE, most of the dates are shown here in the slide are like signing the Vienna Convention, joined UAE nations. All of them are like international efforts, and Also, there is a plans and UAE is acting actively in media regarding this issue. And I will leave this slide for you to check it and read it. Thank you very much. This is again Dr. Saeed Al Ali, assistant professor from UAEU and founder of SPS Law Firm. Thank you for listening to this presentation, and thank you again, Mr. Amar and AIJA for this invitation. Thank you all.
Thank you, Dr. Saeed. It's really interesting to see the increases in the numbers of the climate change cases globally. And what makes it more interesting that most of the cases that you discussed was in Asia and one case in Africa. We believe that the people, organization, and state really realize that the importance of contributing toward the environment which they live in. But I have just a final question for you, Dr. Saeed. Do you think that it's the right time to have an international environment court? And do you think that it would provide more justice toward the climate change by ensuring more respect to the rule of law? Or do you think that we need more sophisticated domestic legislations and international treaties and conventions to fill the lack of having a strong compliance mechanism? Or do you think that we need both of these things?
I think, yes, we need both of them, basically because the largest amount of emissions coming not from the poor countries or the not from Asian countries. They are coming mostly from Western countries. So if we did not act internationally for this problem, we will not solve it. So we need to act internationally and also domestically. So in every country, we need to see actions in the courts, and also in international side, we need to see an actions. I don't like the international court idea, and I will not be advocate for this idea, but we need actions. We need actions like conventions, like we already have, but complying with these agreements could be the issue here. But not, in my opinion, not as a court.
Thanks again, Dr. Saeed, and we are really pleasure to having you today in our panel. So moving or turning to Dr. Mohammed Shamsi now. Dr. Shamsi is a Deputy Director and Associate Professor of Law of the or in Dubai Police Academy. He holds a PhD in law from the University of Sheffield in UK. He is a founding member of the Geneva Center of Human Rights Advancement and Global Dialogue, an independent think tank established in 2013, and has since served on its board of management. Prior to this, Dr. Shamsi held a position of high responsibility, among other. He was a delegate of the UAE to the Vienna Convention of Corruption, 2002 and 2003, and to the Arab International Conference on Combating Corruption in Riyadh 2003. Dr. Shamsi is also a chairman of the UAE Association of Lawyers and Legal Consultants since 2021, and the chairman of the board of the UAE Coordinating Assembly for Occupational Societies since 2013. We are delighted to have you, Dr. Mohammed, with us today, and the floor is yours.
Thank you, Mr. Omar, and good morning to everybody who's joining us for this webathon. Omar, I think you have got my slides. If you can share it, and I will let you know when to flip it. You know, if you can control it from your side.
Okay, just a moment. One moment.
Yeah, thank you. I'll let you know when to flip from one slide to another. So good morning again for everybody who's joining us for this webathon, and I would like to thank the AIJA for inviting me to give a speech or to present this paper in this important conference or through the net. It is with great pleasure and honor that I'm participating with you on this Rule of Law webathon about the effects of climate change through international law and diplomacy, and the possible effects that the new international rule of law on climate could have in social and economic development. What I would like to start with is like to say this statement where you will find it in any conference dealing or handling the climate change. They will say climate change has become an unprecedented challenge for humankind due to its severe consequences for our environment. Especially in the last 3 decades, global warming has been increasing rapidly, predominantly caused by the combustion of fossil fuel such as coal, oil, and gas, as well as by continuing deforestation. Consequently, the issue of climate change, its far-reaching effects, and the urgently needed countermeasures nowadays top the political agenda in many countries around the world. What makes climate change different from any other political topics is the mere fact that the climate crisis cannot be solved by a single world power or a group of states. The whole of humankind has to cope with the consequences on a planetary scale. Hence, adequate measures to restrict the effects of climate change are needed, and this can only succeed via a global approach. An early approach to address the potential security implication of climate change was initiated by the European Union. In 2007, Germany was the presidency of the European Union, and they directed the European Council. They have set up a European Commission to prepare a report or a joint paper on climate change and international security. This report, published in March 2008, summarized the potential security risks associated with the climate change. Broadly, the report outlined that climate change has the potential of becoming a threat multiplier, exacerbating existing tension and potentially creating new ones over time. Among the main security-relevant threats of climate change that the EU identified were conflicts over depleting resources such as water and food, and the economic damage and risk caused by the increase in sea level, and in the strength of and frequency of extreme weather events. According to the report, fragile and radicalized situation may be exacerbated owing to the amount of environmental stress and lack of coping capacity. The Council stressed the need to strengthen the EU comprehensive efforts to reduce emission as one aspect of conflict prevention. In the aftermath of this Council conclusion, the main focus of the EU activities has been directed towards enhancing EU capacity for early warning on the one hand, and towards fostering international cooperation with the aim to creating dialogue and common awareness in the relevant international forums, including the UN and the others. Omar, if you can flip to the other slide. In 2011, the United Nations Security Council expressed also the concern that the possible adverse effects of climate change could in the long run aggravate certain existing threats to international peace and security, and that the loss of territory in some states could have possible security implications. In a statement read out by the Council President, Peter Wetting of Germany, followed by a long debate on maintenance of international peace and security, the impact of climate change, he noted that conflict analyze and contextual information. Among others, the possible security implication of climate change was important when climate change drove conflict, challenged implementation of council mandate or endangered peace process. United Nations Secretary General, the then United Nations Secretary General Ban Ki-moon also, when he opened the council debate on 2011, pointed to the devastation impact of extreme weather and rising sea on lives, infrastructure, and budget. He noted that we must make no mistake, the facts are clear. Climate change is real and accelerating in a dangerous manner. He declared that it is not only exacerbating threats to international peace and security, it is a threat to international peace. It is a threat to international peace and security. We will find throughout the world events in Pakistan, Pacific Island, Western Europe, China, and the Horn of Africa, among other areas, illustrated the urgency of the situation. He said, worldwide, hundreds of millions of people were in danger of food and water shortages. Environmental refugees were reshaping the human geography of the planet. The statement clearly framed climate change as a potential source of conflict, a potential threat to national and international peace and human security. The future role of the United States Council with regard to climate change remains to be determined. The Council would arguably be acting within its legal power. If, for example, if passed a resolution requiring government at all levels to prioritize adaptation strategies in their planning and national government to contribute military or other resources to global disaster mitigating unit. On a presidential statement, a non-legal binding document adopting by consensus expressing concern that possible adverse effects of climate change may in the long run aggravate certain existing threats to international peace and security. Omar, if I can ask you to change the slide to the next one. The current discussion focused on the international community and the territorial states in cases of natural disaster, raising the question whether the doctrine of the responsibility to protect can actually be extended to the international law relating to disaster relief, and in particular to cases of grave circumstances such as severe human suffering during times of natural disaster. Unfortunately, so far, for international law and politics, it still seems to make a big difference whether human suffering is the result of natural disaster or of an international armed conflict. The Kyoto Protocol are an articulation of law states balancing their sovereign right to follow their own development agenda with their overall responsibility under international law, including those measures aimed at avoiding harm to areas beyond the limits of national jurisdiction. This means that the global nature of climate change demands that states scale back some of their sovereignty by engaging in international cooperation and negotiation in the interest of the common concern of humankind. Efforts to curb climate change have given rise, sometimes in conjunction with development in other environmental regimes, to the evolution of new principles and concepts of international law, including the principle of common but differentiated responsibility, the notion of common concern of humankind, protection of vulnerable countries and others. With regard to the application of the responsibility to protect doctrine to climate change. It is argued here that existing relevant international obligations, such as the responsibility to avoid transboundary harm, must be seen in a broader context in order to widen the international responsibility to protect people and ecosystems at the same time. Lately, there was a report by the World Government Summit. The report released last month, in the report, it shows that the Middle East and North Africa region was likely to be the first to face the risk of depleting fresh water, with water scarcity projected to increase by 15% in the event of global warming of 2 degrees. The report by the government summit, the World Government Summit last month, also warned that climate change is set to wreak serious harm on global stability and development, and it urged the private sector to do more to help the world avoid environmental catastrophe. Omar, if you can once more change the slide. Although everyone seems to be aware of the necessity of global cooperation, finding a supranational consensus is practically impossible, as the political and economic interests of countries around the world interfere in finding an adequate solution. Thus, the progress in international negotiation is very slow because of what is called states' interest. We will see that the preamble of the United Nations Framework Convention on Climate Change affirms that the change in the Earth's climate and its adverse effects are the common concern of humankind. However, the preamble of the United Nations Convention affirms that the states have the sovereign right to exploit their own resources. This reflects the notion of permanent sovereignty in international, which entails the right of state freely to dispose of their natural resources. The notion of common concern globalizes certain natural resources and accordingly may be in conflict with the notion of permanent sovereignty, since the right of states over their natural resources must be exercised within the confines of the aforementioned global responsibility. Omar, if you can change the slide, please. So how should common concern and permanent sovereignty in the international climate change regime can be reconciled? The common concern exists in relation to the consequence of climate change. The consequences of climate change are the result of the greenhouse gas emission that occur in states and the way in which states regulate or omit to regulate the latter in terms of their territorial sovereignty. The atmosphere may be viewed as the global environment resources, since it does not fit in any of the other categories such as the shared resources. The fact that the climate change creates a legitimate interest in relation to the action or omission of states in their own territories concerning global environmental resources may be difficult to reconcile with the right of the state and people freely to dispose of their natural resources. So states still have a right freely to dispose of their natural resources. Developing countries are in need of economic growth in order to alleviate poverty. Developing and developed states still have different environmental agenda. The developing world is plagued by environmental problems of poverty, and the developed world by the environmental problem depriving from the excess of influence. Recalling permanent sovereignty or rendering it obsolete will mean that the developing world will be unable to address its environmental problems. It must be borne in mind that the sovereign rights of states over natural resources have never been absolute. This is recognized in the preamble of the United Nations Climate Change, which affirms that permanent sovereignty must be exercised pursuant to environmental and development policy and should not cause damage to the other states. Last, Omar, please, last slide. In conclusion, we say that the challenge of strengthening national and international climate change policies, sustainable development, and increasing equity around the world are above the capacity of national governments. Thus, international climate change cooperation and protection efforts are crucial not only in the context of national but also global security. The impact of climate change are obvious to state borders and require global cooperation. Adverse climate events not only deepen the poverty, vulnerability in development countries, they impact in all aspects of human security, either directly or indirectly. The impacts of climate change on agriculture sector are probably of most direct and profound nature. Impacts of climate change, drought, and floods in particular will have an impact on food availability, food access, and nutrient access. The ultimate damage of climate change may significantly affect economic growth. Climate extremes exert substantial stress on low-income population in particular. The poor are most vulnerable to multiple dimensions of climate change, such as heat waves, sea level rise, the destruction of coastal zone, and water shortage due to the drought. Although the problem of climate change is rather clear, political solutions are often far and unfair. The international community seemed unable to come up with the agreement that both remedy and substantive cause of climate change and the damage caused by it. So it is time now that there should be an agreement that between the countries in the world that they should come close together, bring all these terms of national security and the terms of sovereignty close together. I think the thing is which can make the gap between the governments when they meet to come to consensus is the terms of sovereignty, terms of development or the agenda of development in the country, the common concern. All these issues has to be reconciled first before they come to international agreement. And then we say that we live in an increasingly interconnected and interdependent world. It is a world bound together, not just by state interest, but also and especially in the context of climate change by an interest in more global cooperation. It should be thus in the interest of all states to uphold the rule of law in the world. Thank you very much. Thank you, Mr. Amar.
Thank you very much, Dr. Mohammed. It was a really interesting speech, and we are really looking forward to have more efforts and initiatives by the governments and the countries to play more important role and more active role on the climate change issue. If there is any question to Dr. Mohammed, please, or if there is anything, please let me know. Otherwise, I think we come to the conclusion today. I don't think so that there is any other question. So thank you for joining us for this panel. Our unprecedented 24-hour webathon, lawyer across the globe and around the clock for the rule of law, doesn't stop here. At the top of the hour, we will go live to join the Inter-America Bar Association for a panel discussing business and human rights developments from the UN principles to due diligence laws. Thank you again, and see you soon. Thank you very much.
Thank you very much. Thank you.
Thanks.
uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. Uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. comfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. comfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. should not be a little bit more uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much. A little bit more uncomfortable about how the rule of law works in our countries to assure that the maximum impact and assistance is made to economic and social development. We hope and trust that you will all participate. The 12 panels during the day will be very well thought out and carefully prepared, and we look forward to your participation. Thank you very much.